topic is the basis of legal authority. And if I were to actually rewrite, another good thing lawyers do, rewrite everything they wrote before and then charge you for it, I would probably change it to the problem of legal authority. Because I think there is a fundamental question, a fundamental problem that we need to confront, particularly after the last century, which in my opinion is the bloodiest and the most brutal century in all of human history. And what made it most brutal is it saw the persecution and death of hundreds of millions of people in the name of law. And there's a profound experience that happened to me when I was practicing law in Germany about 10 years ago. So in this little law office, and this, who appeared very mild-mannered German lawyer, pulled me aside. There are all these beautiful books on the wall. And he pulls out this book in German. He says, "Can you read this?" I says, "No, I don't know German." He says, "This is the Nazi laws. These are still on the books. These are still laws. We just don't enforce them right now." And chills went up my spine. I thought, when's my flight out of here? But fundamentally, that's the problem, because the defense to these horrific actions was, I was just obeying the law. And in many ways, the law became the oppressor, and we lost the distinction between authority and authoritarianism. And that's why I think this question, because that century is not ended. It may be some of the scale and in different places it's moved, but it's a history that I still think haunts our present. So, Joseph Vining, the legal philosopher, has said, law, if it is law, is authoritative, and the authoritative is voice heard. As Joseph Raz has observed, justifying authority, however, involves distinguishing authority in terms of the power to direct action from the mere, in terms of the authority to direct action, from the mere power to force someone to do something. The image that haunts the jurisprudence of HLA Hart is attempting to distinguish law from the armed gunman. In both cases, one obeys, but there is a fundamental difference between obeying the law and handing your wallet over to an armed gunman, notwithstanding that some people might feel that way on April 15th. Legitimate authority entails an obligation to conform one's actions to the commands of another in a way that is fundamentally different from the threat of a gunman. The effect may be the same, the completion of an action complying with the wishes of another or the instruction of another, but the nature of that conformity is different. In the case of the gunman, conformity may be necessary to avoid harm, but it is not normatively obligatory. It is not an act of obedience to conform to the gunman, even if it is prudentially expedient in the circumstances. Although a threat may be added to the instructions of law, classical definitions of law never referred to punishment or threat in the essential definition of law. So what made a law was not the threat of harm, but something different from that. The threat or the punishment may be justified if it is a law, but not vice versa. It is not the threat of punishment that makes something a law. As Randy Barnett explains, a lawmaking system is legitimate if it creates commands that citizens have a moral duty to obey. In the pithy words, again, of Joseph Vining, legal authority produces a willing obedience. By willing, he doesn't mean the same thing as being happy or pleased about conforming one's action. It actually means willing to obey even when we might not want to obey. Now, there are two broad categories in my mind of ways that modern legal philosophers have tried to justify legal authority and distinguish it from an armed gunman. And in our short time, I apologize because I can't do justice to all these theories. So we'll just do sort of sweep broad brushes. The first broad brush approach are those called consent scholars who say, well, legal authority is justified because it's like a contract. And you can force me to pay you if you've entered into a contract because I agreed to it. So I obey the law because we agreed to obey the law. The problem is, this is not rooted in reality. I tell my contract students when I teach contracts, if any of them write a final exam explaining that Rousseau's social contract is a contract, they'll fail. Because it actually bears no resemblance to what we actually consider a contract. Real, willing consent of the actual person bound to the contract. Not a single person in America today has consented to our government. or our form of government at all. None of us, right? And even if it could be proven that every single American consented over 200 years ago, what would that mean to us? What right does someone 200 years ago have to bind me to something that I wasn't even born for at the time? But even if this were true, I said it's not true. Because if we look at history, and I'm here quoting from Christopher Ferrara, The Liberty, the God That Failed, at the time, no more than about 5% of the American population at the time, or about 160,000 white male voters, actually cast votes for delegates who actually ratified the Constitution. Of these 160,000, approximately 60,000 opposed the Constitution. Thus, it was only a few hundred delegates at ratifying conventions whose votes represented the will of about 100,000 people in a nation of some 3.5 million, a figure which includes the entire slave population. So on the consent theory, these 100,000 white men who own property consented for all of us. This can't be a sustainable basis for authority. And in fact, most consent scholars admit it. So they've sort of thrown out the idea of consent, and they say, well, what there is actually is tacit consent. You don't really consent, but it's as if you consented. Some of them do this by saying, because you get benefits from the government. Well, again, this poses a problem. How do you opt out? Number one, you can't even leave this country without the government's permission. You can't go to another country without that government's permission. So in a sense, it's still a forced consent. Here's a bunch of benefits we're going to force on you, and now that means you've consented because you've accepted them. As again, Randy Barnett Riley notes, it's a queer sort of consent where there is no way to refuse. Heads I win, tails you lose is the way to describe this kind of rigged consent based on benefit. In other words, my phrase, heads you consent, tails you consent, you don't flip the coin, guess what? You consented as well. You're bound by the law. So most scholars who are actually upfront about this now talk about fictional consent. People have consented not to anything in reality, but what they should consent to. John Rawls says, the choice which rational men would make in this hypothetical situation of equal liberty determines the principles of justice. Thus, we the people must obey the laws because we have hypothetically consented to what John Rawls thinks we should have consented to if he asked us, which in fact he never does. Consent has turned into a hypothetical or imagined consent. And in fact, one of the most frank scholars actually says this outright. Paul Kahn says of consent, to see through the Constitution to the popular sovereign whose act it records is what makes it literally our Constitution, despite the fact that we as finite individuals neither wrote it nor approved it. This is not a matter of implicit consent, he says, but of a social imaginary that grounds faith. The Constitution claims us not because it is just, although we want it to be just, but because it is a remnant of a politics of authenticity that we imagine is our own. So now we're left with imaginary consent. Again, I think these theories are dead ends because they don't reflect reality. The second type of approach is what I call the utilitarian theories. They basically say, hey, we're better off with law than without it. And again, this is also based on an imaginary. It all starts with Jean-Jacques Rousseau's State of Nature, that never existed, never really existed, is just something he thought up in his mind sitting in his armchair in Paris. So again, it's all based on imagined circumstances, not actual reality. It uses this fictional state to just posit that we're better off than we were when there was supposedly an anarchy that nobody could ever prove actually existed, because in fact it didn't. Moreover, it doesn't prove legitimacy or that authority is good. It merely posits authority as instrumentally better off than some other alternative. Some scholars, like John Finnis and Joseph Raz, try to talk about values and good and things, but in the end, it's still utilitarian. For Finnis, authority is justified because people, in fact, actually obey, and therefore we're better off. A sort of circular argument. Raz's service conception says authority is justified because those in authority can make the same decisions we would have made, but in a better way, a more efficient way. Rather than us deciding for ourselves, it's just more efficient. Well, this comes to Raz's famous stoplighted example. If it's merely instrumental, well, what about cases where it's not efficient? I'm sitting at a stoplight at 2 in the morning, there's nobody around. Why should I stop? They thought it was, but they're just a substitute for what I can decide for myself. So we're only obeying the law when we would have obeyed the law anyway because we would have decided to. So again, it doesn't fundamentally get to this notion of obedience to the law. Ultimately, I think all utilitarian claims to justification of authority are instrumental goods. And they all rest on unproven and unprovable claims that authority is, quote, more efficient than not having it. In the words of the philosopher Alasdair MacIntyre in his wry critique, he's argued this claim is a fiction created to justify the fact of the power of managerial bureaucrats to run the state. In any event, authority has no real existence. It's merely just it's better than something than the alternative. So, what stream of thought, what theories could actually offer a real ontology to law? To say it's something actually really good, not just fictional consent or better than nothing. Essentially, this is the classical view of law. Summed up in the aphorism, all authority comes from God. And what's interesting about that phrase is it's uttered, not exactly those words, but the same concept, by people as diverse in religious beliefs as Cicero and St. Augustine, who, as I think you would agree, have a pretty fundamental difference about who God is, well, in fact, whether he's one or many. But in fact, that's their understanding of law, that authority must come from above, from somewhere outside of human existence. Even Joseph Raz, who certainly would not ascribe to this view, says all authority must be given from another. An old legal aphorism, nemo dat. One can't give what one doesn't have. Even if we all consented, where's the authority that we're conferring on somebody? If we don't have authority over anybody else, so how can our consent confer authority on one person over the entire country? C.J. Bateman has said, from Hammurabi to Hadrian, and even on past to the Habsburgs, the only affective benefactor of sovereignty was, at least in theory, the deity. In societies where religion was the fundamental framework of daily life for all classes, rulers, or for the sake of legitimacy, had to acknowledge that it was God or the gods who had bequeathed their sovereignty on the human race. In this context, sovereignty was neither aggressively or individually understood as solely attached to either the will or skill of persons. It came from above. Authority, in the classical view, is written into the fabric of the universe. And in summarizing this very quickly, from Cicero again through Augustine and Aquinas, through to even the founders of this, many of the founders of this country, there is an eternal law which establishes the nature or essences of things, including human nature. We need to work together in our social context to discover this pattern to the cosmos. This eternal law confers a great dignity and freedom on us as rational creatures. Why? Because unlike other worldviews, particularly Eastern Oriental views, this idea of eternal law is not the idea of a detailed, specified legal code. In his Islamic understanding or many Eastern understanding, what they mean by a divine or eternal law is here's a detailed prescription. Everything's done. Just copy it down. In the classical view, this eternal law presented natural, general principles. Life should be preserved, for example. Men should live in society. All men should seek the truth. These are not specific enough to actually act upon. And so these general principles need to be specified in more detailed rules. But this eternal law has not done that for us and has given us the freedom and ability to organize ourselves in a way to further specify. And so the act of human lawmaking participates in this act of specifying natural pre-existing principles. As Russell Hittinger has specified, this process occurs in three orders of prudence: the individual, the familial, and what he calls the renutive. Some of these particular determinations need to be made by individual people in their lives. Some of them need to be made by smaller groups, the familial, the personal superiors, parents for children. Others that affect the common good of the political community need to be made by those with care of that community. Functioning in this balance between being constrained by natural principles but having the freedom to specify them. Authority, in this sense, is a participation in a larger sovereign authority of a primary legislator who has written the obligation to write particular laws into the very fabric of the cosmos. Law is a delegation of this authority to participate in this lawmaking process. As rational creatures, we participate in accord with levels of our nature: individual, familial, and political. Not inconsistent, this theory is not inconsistent with the popular selection of the ruler. And again, an important distinction is made here. A distortion of classical legal theory was made in the 16th century with divine right of kings. They conflated the establishment of the architecture of law with the selection of the ruler. The ruler said, well, I'm here because God appointed me. Wrong. This theory is completely consistent with a popular designation of who will exercise this authority. The distinction is between how do we decide who's the person to fill this job and who creates the job in the first place. Again, a more human example might help with this: the analogy of procreation in the family. A parent does not become a parent until there's a child. The fact of the child makes someone a parent. But we would never say that the child gives authority to the parent, right? The fact of the child coming into existence predisposes the matter of the man and woman to be parents. But that authority over the child doesn't come from the child themselves, even though it is the child that identifies them as a parent. Likewise, whatever process is used to pick political authorities, again, whether it's an elected monarchy, elected aristocracy, whether it's elected by the populace or republic, is different from creating the power to change people's normative positions. It's merely specifying the office holder. What's, I think, important about this broader classical view that we've only just had time to summarize is that, unlike the 20th century dehumanizing of law, it makes law personal again. Because modern theories of law, which removed a person from the origin of the legal system, it removed the personal aspect of law all the way up and all the way down. Authority then ceases to be personal and becomes merely abstract principles take the place of a personal authority. Whether it's Hart's rule of recognition or Kelson's basic norm or the construct of we the people, concepts and abstract ideas take the place of personal legal authority. Another example of this is Justice Scalia's rigid textualism, in which his jurisprudence is trapped. As Professor Brennan has said, it is a systemic campaign to eliminate the problem of authority in law by eliminating the source of authority, to make law not personal, but an abstract text. Law should be personal all the way up and all the way down. As Brennan said, the crux of the matter is that law is an ordinance of reason, not a piece of paper. The law is only in the paper metaphorically. To know law is to receive something from a mind, the mind of the lawgiver. Grounding human authority in the eternal law of nature provides the only answer to what Stephen Smith has called law's quandary. Does the law exist, or is it only an abstract construct? Utilitarian and consent or popular sovereignty theories might say something about law or something about why some people happen to obey it, but none of them provide answers to the big questions. If law and legal authority really exist, where did they come from? As Joseph Vining has commented about Stephen Smith's work, the classical view of law, running from the ancient world through Christian jurisprudence, maintained that the key to the big question lay in something beyond us. Vining observes, Smith begins with an overarching sense of law, classical or traditional, preceding the development of the 20th century. One view which he outlines is that this overreaching sense depended upon and likened human law to divine law and divine judgment. The modern break with this ontology created a metaphysical gap, which the modern theories have attempted to patch together, but which has left us with mere abstract pieces of paper or principles that turn law into the authoritarian rather than authority. As Brennan says, and here the connection with religion, the work to make law heard proceeds only on presuppositions. If it does not proceed on these presuppositions, it does not produce anything in which there is any sense of obligation. That which evokes no sense of obligation is not law. It is only an appearance of law, the legalistic, the authoritarian, not sovereign, but an enemy. Principal among these presuppositions of legal work are that a person speaks through text. There is a real mind behind the legal cosmos. That mind is a caring mind. There are the links between the expedience of law and religious experience. And ultimately, it saves us from the authoritarian because its origin is outside us. As much as the classical theory elevated the idea of legal authority, gave it a great dignity by a participation in the eternal law, it also at the same time brought a restraint that the 20th century lacked. Law cannot be whatever we happen to want to make it at any particular point in time. And therefore, we have a qualified obligation to obey the law. When it fits into this system, this eternal cosmological system, it is a good to obey it because that's the way the world works. And we are participating in this good of specifying for ourselves the details of natural principles. But when it jumps off of its jurisdiction, when it transcends that system, it is not a legal law, to use the phrase of St. Augustine, but a mere violence. This is a vast topic, not for today, how we draw those distinctions, and when one may be obligated to actually break the law, in quotes. So again, I hope I've given you some challenging thoughts, if not provided any answers. Thank you for your attention.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.